Welcome to UXL, where you can learn new skills anytime and anywhere. Visit uxl.com to explore our full course selection. This lesson is part of a larger course. Check the video description below for a link to the full course where you can enroll. If you enjoy our content, please like and subscribe. For your convenience, the course cover displayed on your screen provides the complete course title and lesson title. Let's proceed with the lesson. Lesson: Reductions in Force and WARN Act Requirements. Reductions in force are a critical and often challenging aspect of human resource management, especially in the context of compliance with legal requirements such as the Worker Adjustment and Retraining Notification Act. When an organization decides to downsize its workforce, it must navigate a complex legal landscape to ensure compliance with federal and state laws, particularly in California, where labor laws can be more stringent. Understanding these requirements is essential for HR professionals aiming to achieve the PHRca certification and effectively manage termination and employment separation processes. The WARN Act is a federal law enacted in 1988 to protect workers, their families, and communities by requiring employers to provide a 60-day advance notice of significant layoffs or plant closings. This notice period allows employees to seek alternative employment or retraining opportunities and helps communities prepare for the economic impact of job losses. Under the WARN Act, employers with 100 or more employees must provide notice if they plan to lay off at least 50 employees at a single site of employment or if they plan a plant closing that affects 50 or more employees. In California, the requirements are even more stringent than the federal WARN Act. The California WARN Act applies to employers with 75 or more employees and mandates a 60-day notice for any mass layoff, relocation, or termination affecting 50 or more employees within a 30-day period, regardless of the size of the site of employment. This broader scope means that California employers must be particularly diligent in planning and executing reductions in force to avoid potential legal pitfalls and financial penalties. Failure to comply with the WARN Act can result in severe consequences for employers. Under the federal WARN Act, employers may be liable for back pay and benefits to each affected employee for each day of violation up to 60 days. Additionally, employers may face civil penalties of up to $500 per day for each day of violation. In California, non-compliance with the state WARN Act can result in similar penalties, including back pay, benefits, and civil penalties, emphasizing the importance of adherence to these regulations. The process of implementing a reduction in force involves several critical steps to ensure compliance with the WARN Act. First, employers must determine whether the planned layoffs or plant closing meet the thresholds for requiring notice under the federal or California WARN Act. This involves a careful analysis of the number of employees affected, the timing of the layoffs, and the specific circumstances of the employment site. Employers must also consider any exceptions to the WARN Act's notice requirements, such as faltering company, unforeseen business circumstances, or natural disasters, although these exceptions are narrowly construed and require substantial evidence to support their applicability. Once it is determined that WARN notice is required, employers must prepare and distribute notice to the affected employees, the state dislocated worker unit, and the chief elected official of the local government where the employment site is located. The notice must be specific and detailed, including information about the nature of the layoffs, the expected date or dates of the layoffs, and the job titles and number of affected employees. Employers should also provide information about available resources for affected employees, such as outplacement services, retraining programs, and unemployment benefits. Effective communication is crucial throughout the reduction in force process. Employers should strive to be transparent and empathetic in their communications with employees, recognizing the significant impact that job loss can have on individuals and their families. Providing clear and timely information, as well as support and resources, can help to mitigate the negative effects of layoffs and maintain a positive relationship with the workforce. Additionally, employers should be prepared to address any questions or concerns from employees, as well as to manage the potential impact on employee morale and productivity. In addition to legal compliance, ethical considerations play a significant role in the reduction in force process. Employers have a responsibility to treat employees with dignity and respect, even in difficult circumstances such as layoffs. This includes providing fair severance packages, offering support services, and ensuring that the decision-making process for layoffs is based on objective criteria rather than discriminatory factors. By prioritizing ethical considerations, employers can help to maintain trust and credibility with their workforce and the broader community. Statistics highlight the prevalence and impact of reductions in force in the modern labor market. According to the U.S. Bureau of Labor Statistics, there were approximately 21,000 mass layoff events in 2020, resulting in over 4 million initial claims for unemployment benefits. These figures underscore the importance of effective and compliant RIF processes for both employers and employees. In California, the Employment Development Department reported over 3,000 WARN notices filed in 2020, affecting more than 650,000 employees, reflecting the significant impact of economic downturns and business restructuring on the state's workforce. Case studies provide valuable insights into the practical application of WARN Act requirements and the challenges employers may face. For example, in the case of Local 217, Hotel Employees and Restaurant Employees Union v. MHM, Inc., the court ruled that the employer had violated the WARN Act by failing to provide adequate notice of layoffs to employees at a hotel in New Haven, Connecticut. The court awarded back pay and benefits to the affected employees, highlighting the importance of strict compliance with notice requirements. Another notable case is Collins v. G. West Seattle LLC, where the court found that the employer's failure to provide timely WARN notice resulted in significant liability for back pay and benefits to laid-off employees at a manufacturing plant in Seattle, Washington. In conclusion, reductions in force are a complex and sensitive aspect of human resource management that require careful planning, clear communication, and strict compliance with legal requirements such as the WARN Act. For HR professionals seeking to master the PHRca certification, understanding the intricacies of federal and California WARN Act regulations is essential to effectively managing termination and employment separation processes. By prioritizing legal compliance, ethical considerations, and effective communication, employers can navigate the challenges of reductions in force while minimizing the impact on affected employees and maintaining a positive organizational reputation. This concludes the lesson. We trust you found this video informative and engaging. To enroll in the complete course, please use the link provided in the description below. At UExcel, we are committed to your learning journey. Each course offers a certificate of completion, online support, and downloadable resource files to enhance your experience. If you found our content valuable, we invite you to like this video and subscribe to our channel. Thank you for joining us, and we look forward to supporting your continued pursuit of knowledge.